had Dobbs 2 years ago. And I mean, I'm getting old. I've been covering the court a while. So, I'm like, okay, that was a crazy term. But I've covered the court a long time, and they always take a breath the next term. The Chief Justice Rehnquist would talk about how the court can't get too far from public opinion. And the tides kind of come and go, but they have to lower the temperature sometimes. And so you will see a contentious term, and then it'll be maybe a little more quiet the next term. Well, we didn't get that last term. We had a contentious term last term. So this year, we started out the term, and I mean, I'm I'm talking on the news, and I'm saying, this is going to be a quiet term. I think
Your predictions
so
aren't
far,
good.
It's going to be a term about social media and maybe the role of the administrative state. That's going to be big issues, but we are not going to have these hot button social issues that have really gotten people so riled up and divided the court in such heated ways that we've seen in the past couple years. And so the term starts out, and the court, because they take the cases come to them, they don't reach out and create them. They have to wait, and if there's a split between lower courts, they will take those cases. Well, this year, to start the term in October, the first Monday, it was a really light docket. And so typically, the court likes to really front load the fall arguments. And so they'll have 2 a day, sometimes 3 a day in the fall. And then by the time they get to March and April, they're lighter because, again, you want to be able to work on your opinions throughout the term so you're not just all bogged down at the end. This year was totally different than that. It was very light at the beginning of the term. They hadn't taken that many cases. And then, man, Katie bar the door. It was, we're not even talking about social media anymore. I mean, we do a little bit, but now we have cases on guns. We have abortion, 2 cases on abortion. We have cases about whether or not the unhoused can have their tents taken down, or whether that violates the Constitution's prohibition against cruel and unusual punishment. We have more controversial cases now this term. This is potential to be such a divisive term. And then guess what? We have 3 cases involving the person that nobody really gets too upset or divided about, Donald Trump. So yes, the court has already resolved one of those. And the 3 cases are: 1, to kick him off the ballot. Trump won that one. 1, to see, can Trump be prosecuted criminally for his official acts as president, which Kimberly's already discussed. That's going to be argued on Thursday. They've added that to the docket. And then if he can be prosecuted, the 3rd case involving Donald Trump, will half of the case against him still stand?
Once they decided to pull the pin, as it were, on Dobbs and send this back, there was always going to be a raft of litigation on the follow-up. What are the outer limits of that? How far can we go? And there was going to be states who were saying, we now have carte blanche to do everything. There's going to be federal law saying there are certain limits on what you can do. I think the more interesting thing is that this is kind of working out the way Justice Alito said it would. He said, let's not pretend, we can't pretend to know how our political system, our society will respond to this. We can only do our job, which is to interpret it. And he foretold that this would be a very messy political situation. And it probably is going to be for another decade, maybe another 2.
Jan, anything to add to what we're looking for in the reproductive rights cases?
Well, they've already had arguments in the first abortion rights case since Dobbs, and that was the mifepristone, involving the FDA's approval of one of the drugs used in the so-called abortion pill. That's responsible for more than half of abortions in the U.S. That's how more than half the women who get abortion have the abortion by the use of this pill. And, in the wake of Dobbs, we saw 21 states pass significant restrictions on abortion or bans. But this case, which looks at whether the FDA properly approved this drug used in the abortion pill, could affect abortion rights in states where it's even widely legal and widely available. So this is a case that could have a wide-ranging impact. A group of doctors sued, conservative doctors sued, saying that basically the FDA had not gone about this the right way when they made this pill easier to get by letting women have it at 10 weeks as opposed to just 7, and also during the pandemic authorized its shipment by mail. So a group of doctors brought suit and said that this is unsafe. The FDA didn't go about the approval process the right way, and also it's taking us away because women are being hurt by this drug, and now we're having to treat them, and that goes against our beliefs in the emergency rooms. That case, I think, again, is probably not going to be the big case that people, if you're liberal, are afraid of, and if you're conservative, you're hopeful for. I think the Supreme Court's going to dump that case on what's called standing grounds.
Could not agree more.
Yeah, most of the whole argument, they barely even talked about the legal issues at stake. The whole focus in that case was whether or not these doctors had any business even challenging this law.
We hear a lot of conversation about the emergency docket and the shadow docket, and the criticism obviously is that when you are dealing with things in that sort of capacity, that you're not being fully briefed, you're not getting oral arguments, there's not full debate going on. But a lot of these things are being stuck on them because we have a lot of other institutions that are dropping some of their guardrails and being a little bit more aggressive. So for instance, it really wasn't something the Supreme Court was planning to do to deal with Texas's border law and border situation, but it's something that it suddenly has to do. It really wasn't the Supreme Court's intention to have to be dealing with a case when Colorado decided to strip a leading candidate off of its ballot for the presidency. But the court's decision, and there were many of them that decided to take that case, and then obviously it was decided 9-0, was that the threat to an upcoming election was so great that they had no choice but to handle it. The immunity case that we're going to be hearing for the president in the coming week. There's a lot of things that are just popping up in front of them that they'd probably really rather not be having to deal with, because, and let me point this out, I think there's a certain amount of courage that this court gets credit for, because I'm sure that it would have been their temptation just to let the DC Circuit Court opinion stand on immunity. But the question of presidential immunity goes beyond the current defendant in that case, Donald Trump, to some bigger issues, especially I think the Supreme Court is aware in a day and age, the word that gets used a lot is lawfare, where there are more and more people that are seeking to settle their political battles in courts. And so to the extent that the court can kind of set some ground rules up front, maybe they'll save themselves some grief down the road. But some of this is happening because we have a lot of political players that are taking, I think, more aggressive steps than they have before, and a lot of law and legal issues. Look, none of us want a situation. The Supreme Court doesn't want a situation where it's deciding on cases without full briefing and arguments. The question that they face every time they have to do this, though, is do they have a choice? And, you have some of these cases where it's pressing, it's immediate, and there's not a lot of other opportunity to deal with it other than in this situation.